folks, and welcome back to Contract Law. This is video 7 in the video series for contents of a contract and exclusions. And we are nearing the end of our journey here. In this video, we are going to have a look at implied terms. So in this video series, we have been looking at all of the different ways that terms might be swept into an agreement, even though they may not otherwise be included in the main body of words in the written agreement between the parties, or there may in fact be no written agreement between the parties. So the first stop necessarily when we're looking at what the terms of a contract are, what the contents of a contract are, is that you go to the parole evidence rule. And that says where you do have a written agreement between the parties and it seems like it's intended to be the definitive statement of all of the parties' rights and obligations, then you need to stick to the four corners of that agreement, and the court won't get you to submit evidence of the surrounding circumstances in an attempt to detract from, vary, modify, throw a different light on the terms of the written agreement between the parties. However, there are a number of exceptions and twists and turns, as we saw. Collateral contracts are one exception where the parole evidence rule might seem to apply because there's some form of written agreement between the parties, but then there is an exception here that allows you to introduce evidence to show that there's not just the main body of contract terms that's floating along between the parties. There is also this collateral contract that floats alongside and augments somehow the terms of the written agreement. Where we looked at the incorporation of terms, we had a look at incorporation by things like tickets and signs and all of that kind of thing. But for the bulk of those cases, the parole evidence rule just won't even apply, because as we saw when we looked at the parole evidence rule, it won't apply to partly written, partly oral contracts, and most of those kinds of incorporation cases are of that ilk. And so the parole evidence rule just doesn't even get off the ground in the first place, because there was never that one document that the parties sat down and carefully worked down all of the terms and conditions and then signed off. Okay, it wasn't the kind of scenario, the kind of bargain that would attract the application of the parole evidence rule. So you could have the main body of your contract, might be verbal, might be written, and you've got these terms that have been swept in by a ticket or by a sign, by a website, and that somehow modifies what might otherwise have been thought to be the contract between the parties. When you're talking about implied terms, they're a little bit like collateral contracts in that they're probably not written down anywhere, but they are, like the rest of the incorporated terms we've been talking about, signs, tickets and so on, they are actually incorporated into the body of the contract itself. So unlike where the court would enforce a collateral contract as this auxiliary separate contract, even though the term hadn't been written down anywhere, it might have just been a conversation that happened between the parties. Nevertheless, the court says, okay, this is a separate contract, we're going to enforce it. Mostly with the incorporated terms, you found the terms somewhere. It might be in a signed document, it might be an unsigned document, it might be a notice, it might be a website, and by virtue of the notice and the assent to those terms, you had them swept into the actual bargain itself. Here, where we're talking about implied terms, these are terms really that no one's even really thought of before the issue became problematic. And nevertheless, when you look back on it and you think, would this term be in the bargain? Yes, generally speaking, you would. And for that reason, then, they are swept into the actual bargain itself. However, while implied terms are swept into the main body of the bargain between the parties, they are more like collateral contracts in that they are more of a true exception to the parole evidence rule. There are some twists and turns to that, but we'll deal with those in just a moment. Implied terms generally fall into one of two kinds, and they will be terms implied by the common law, by general law, because they implement the party's presumed intentions. And here we have what I call the 3 C's. Actually, they're not 3 C's, but I like having lots of things, so we'll call them the 3 C's. Custom, course of dealings, and business efficacy. That's my 3rd C. Sometimes where you imply a term because of business efficacy, it's called implying a term in fact. Okay. The second scenario where you might find implied terms is where they have been implied at law. And here, these kinds of terms will be implied regardless of the party's intentions. They will just be implied as almost a matter of policy by courts. And these are terms that have been worked out either over time in relation to a particular class of contract. They might be implied to all contracts, like a general duty to cooperate. You might also find terms implied at law because of something that a piece of legislation says, or a statute says. And here we come across the sale of goods legislation and the Australian consumer law. So looking first at the terms that are implied because they represent the presumed intention of the parties, we have the first C, which is custom or trade usage. And here, no real rocket science, the term just finds its way into the party's bargain, even if it's not written in there, because it's part of the custom in those circumstances, or because the parties belong to a certain professional trade, and those terms are always included by that professional trade. Much more relevant in the early days, 19th century, more prevalent arguments of this nature were made, not so relevant nowadays, but Hutton and Warren is just a good early example of this. We had a leased farm, the tenant was given a notice to quit. They claimed that there was this custom that tenant farmers, upon being given a notice to quit, were entitled to be paid for the amount that they'd spent on seed and for their labour on the land in the last year of the tenancy. There was sufficient evidence of that custom existing, and so the tenants succeeded, they got their payment. We had an unsuccessful attempt at implying a term through custom in Constan. In that case, we had payment by an insurance policyholder of the premium to an intermediary, the insurance broker, and the insurance broker then disappeared from the scenario, didn't forward on the payment to the underwriter, and then the ultimate dispute was between the policyholder and the underwriter. And the question was whether the underwriter could claim the payment of the policy directly from the policy owner. The policy owner says, hang on a minute, I've already paid my premium, and there should be this term implied into my contract that in insurance contracts the trade custom is that payment to the insurance broker will constitute discharge of the obligation to pay the underwriter. Failed in those circumstances. So why is that? Well, the court established 4 propositions that have to be satisfied before you can imply a term on the basis of custom. Firstly, obviously, and here is your exception to the parole evidence rule, you have to get sufficient evidence before a court to show the existence of a custom that justifies the implication of the term. It's a question of fact. You've got to have the evidence for the court to determine on the facts whether or not there is this custom. But it's not just sufficient to show the court that a custom exists, okay? You have to be able to show that the custom is so well known and acquiesced in that everybody making a contract in those circumstances can be presumed to have imported that term into their contract. And obviously in Constan, the policy owner was unable to show sufficient evidence that would satisfy those propositions. Thirdly, the court said that you also have to be able to satisfy the proposition that it is not contrary to any express terms of the contract. Just makes sense, doesn't it? You can't introduce extrinsic evidence of a custom that directly goes against what's being said in the main body of the contract. You can't introduce uncertainty into your contract by trying to imply a customary term. Okay, so one case example in point there is Summers in the Commonwealth. There was a supply of marble. It was the wrong size according to the contract. The supplier tried to argue that there was this convention in the marble trade that you could deliver blocks large enough to actually be cut into the size that was required. The court said no, the contract itself specified the size. You've got to actually give them blocks of marble that particular size. So that was your third requirement. Your fourth requirement is you can actually be bound by terms that are out there in custom, out there in trade usage, even if you're unaware of them, so long as they should have been aware. And this, this should be sounding relatively familiar to you from our work on incorporation of terms. There's your element of assent. Why are the parties bound by this implied term in this circumstance? They should have been aware of it because everybody in the custom, everybody in the trade knew about it. So that was Constant. Spectacular failure in that particular case. The second C is where you have a course of dealing. So a term might be implied into a contract because through backwards and forwards between the parties over time, it was clear that the term was brought in, even though it was not perhaps written down anywhere. And in Balmain New Ferry, we saw one of my favourite cases. Mr. Robertson had missed his ferry. Him and his lady friend worked out there wasn't going to be another ferry for about 20 minutes. So they tried to get off of the wharf without paying their penny to exit the wharf. As they had walked in, there was this sign, and they said even if they were strangers to the wharf, to the ferry company, in this circumstance, the notice itself probably would have constituted reasonable steps to bring that term to Mr. Robertson's attention. However, the real basis in that case, in terms of the contract between the parties, was that Mr. Robertson had been on that wharf a number of times before. He'd seen the sign. He knew what the whole thing was about. You have to pay a penny to get on and a penny to get off. And so the term was implied into his contract through that course of dealing. Another case that just illustrates this particular C of implied terms is Henry Kendall and Sons. And here we had a rather unfortunate case. I call it the Chook case. A rather unfortunate case of the sale of contaminated chook food, and it had been shown to the court that over 3 to 4 dealings a month during the past 3 years, the parties had dealt on the basis that they would conclude the supply of the chook food, and then there would be this sold note that got given to the purchaser after the chook food had been delivered. That sold note purported to exclude liability, here we have one of those nasty exclusions, for latent defects, so defects in the quality of the chook food. The plaintiff hadn't actually read the sold note. Nevertheless, they knew that it had terms and conditions on there, and they knew that Lillyco dealt on the basis that those terms would be applied to the transactions. Given that there had been so many of these transactions, the court basically said that those terms were implied by a course of dealing. Now, of course, you couldn't have that logic being applied to the first dealing, could you? Because there had just been this transaction and then you had the sold note with the terms. It's too late to try and get those terms into the first contract itself. But where you've repeated that dealing and where the purchaser is very well aware that that particular note contained terms on which the parties would be dealing in future, then it was implied. DJ Hill and Wright we have already seen when we were looking at incorporation of terms previously. And we had there, remember, verbal contracts to cart machinery, to carry machinery. there was only about 10 occasions of carriage, and each time after the machinery was carried, remember we had this document that was produced for signature, and it included another exclusion clause excluding liability for loss or damage. In that case, at no time did the defendant regard the document as anything more than an acknowledgement of delivery. His machines had arrived, here's the paperwork, fine, no problem, and on they go. There was never that awareness, that assent as a matter of contract, that those documents would contain terms on which the parties would purport to deal. That plus the fact that there had been only about 10 occasions, not sufficient to establish an implied term by way of course of dealing. And finally, we come to the last of the C's, business efficacy. Sometimes you'll see these referred to as terms implied in fact. They are probably argued a little more often than terms that are said to be implied by way of custom or by way of course of dealings. However, the courts will not just let any old argument of business efficacy allow somebody to slip in a new term to a contract. If you let parties do that kind of thing, you're going to undermine the whole notion of certainty of contract, aren't you? You're going to very seriously impact on the whole reach of the parole evidence rule that otherwise would make the parties stick to the four corners of their contract and not introduce extrinsic evidence in. And for this reason, it seems to be, and some of the texts like Wilmot talk about this issue, that the nature of evidence that you are allowed to put before a court in aid of an argument of implying a term for reasons of business efficacy seems to be saddled with this extra requirement that you need to have some form of ambiguity in the terms of the contract as it's written before then the court will allow you to bring your extrinsic evidence in and defeat the parole evidence rule. So if you're interested in that issue, I would encourage you to have a little look at the Wilmot text, Wilmot, Christensen, Butler and Dixon contract law. But certainly this is not an easy test to get over by any stretch of the imagination. The case that's bandied about the most in terms of implying terms for business efficacy is the Mongkok case. And in that case, we had a plaintiff contracting with a defendant to bring their ship up next to its jetty to discharge and load the ship. Both parties knew that in order for that to happen effectively, the ship had to be moored, and in the process, the ship would ground, it would take ground, that is, settle on the riverbed. In the course of performing the contract, the tide went out, the ship settled down and onto a hard ridge of sand that was about in the middle of the ship. The ends of the ship, therefore, were unsupported, and the ship broke its back, according to the court. Now, the question there was, could a term have been implied that the defendant would take reasonable care to ensure the riverbed wouldn't cause damage to the vessel? And successful case of implying a term for reasons of business efficacy there. I've taken that picture from a lovely article by David Ash. Highly recommend you reading the article if you can manage to find time to do so. It's on Moodle. But in that case, it was said in business transactions such as this, what the law desires to give effect by the implication is to give such business efficacy to the transaction as must have been intended at all events by both parties who are businessmen. So that case then sparked off a long line of cases in this area. Obviously some in the UK, some in Australia. The case that's probably of most significance for Australia is the BP Refinery case, and appealed all the way up to the Privy Council, and some perhaps surprising decisions made there on the particular facts at hand. I'll leave you to read the David Ash article that has a rather humorous commentary on this. But Hastings Shire Council had contracted with BP to provide it with significantly discounted council rates for about 40 years. Why is that? To encourage BP to actually go ahead and build the refinery in its jurisdiction in the Hastings Council area. The issue was that BP, as part of a company restructure, restructured its entities. It left the premises for a while, it came back, and then the council took the opportunity to try and say, oh, hang on a minute, you're not going to get discounted rates anymore. The county and full courts there said that there was an implied term, the discount would only apply while the company was in occupation. So that when the company ceased to occupy the premises, that obligation to give the discounted rates was terminated. Obviously, BP, being a British company, wasn't terribly happy with that. Where do you appeal to? You appeal to the Privy Council. And in that case, the Privy Council accepted this alternate argument that was effectively suggested to BP in oral submissions, rather interestingly, that you might be able to imply a term that the use of the word company in the original agreement between BP and Hastings not only meant BP, the original company as it was constituted in the first place, but any assignee that would come into existence or that might be deemed appropriate as a result of company restructuring. So the council was obliged to continue with its discounted rates. Now, in that decision, there was some fairly sensible judicial decision making there, and the majority held that the term has to be reasonable if you're going to imply a term for business efficacy. Has to be reasonable, has to be equitable, no problems there. Has to be necessary to give business efficacy to the contract. Now, this is a significant obstacle if you think about it. No term is going to be implied if the contract is effective without the implied term. So if you can still make the contract work, then in all likelihood you won't be able to imply this term that you want to imply. However, as we've seen throughout this unit, where there is a stated rule, there is quite often some judicial two-stepping and some funky decision-making that gets made in order to try and circumvent the rule. And you do see courts applying different standards of necessity on this limb of the BP refinery case. You do, in some circumstances, have courts saying if the contract still works without this term, you can't imply it, as they did in Constant. In other cases, you have the court showing a more perhaps lenient view of the word necessity. And if you're curious about that, have a look at the Ling case. But that's the second limb of the BP formulation. The third one is that it has to be so obvious that it goes without saying. So if a reasonable person was asked if this particular term were included in the contract, they'd say, of course. Okay, so it has to be very clear that it's supposed to be in there. It also has to be clear in terms of the way that it is expressed. If a court has to get out its blue pencil and effectively write a whole term and apply a serious amount of thought into how you could formulate this term, it's not going to be the kind of term that will be implied. It has to be very, very clear to all and sundry what the term should say. The fifth element is that it must. I think there was a movie about that.
Lilu Dallas Multipass.
It must not contradict any express term of the contract. And again, as we saw previously, you're not going to be able to insert an element of uncertainty into a contract by way of implying a new term that somehow says something different to the rest of the body of the written terms. Okay, there is another nice little issue about whether or not entire agreement clauses have some bearing on this issue. I'll leave you to explore that on your own. But that is the 5-limbed test from BP Refinery. Like I said, a very sensible test when you look at it. However, when you look at the decisions that were handed down in the Privy Council on the facts of this particular case, as Ash says, you may well prefer the minority judgment to the way that the majority went about applying these requirements and actually implying the term there. And finally, we come to terms implied at law. So unlike the terms that we've been looking at so far, they don't rely at all on being some form of indication that they are the presumed intention of the parties. Courts will imply these terms as a matter of law if they see fit. There are a few different times when you might see terms implied at law. Firstly, they might be implied just at common law as an incident of decision making in all contracts, and there's one main way there, or in particular classes of contract, or you might find courts implying terms at law because of the words of a particular statute. So these ones are far less craggy and detailed than terms implied by the common law or general law for being the presumed intention of the parties. So we can wrap these up fairly expeditiously. The first kind, and probably most obvious kind of term implied at law, and this one's implied for all contracts, is just a general duty on the parties to cooperate. No real rocket science here. It's just implied by courts as part of the general machinery of the contract so that the parties can actually get the benefit that they'd intended out of the contract. Don't, however, think that the general duty to cooperate extends to the notion of a general duty to perform your contractual obligations in good faith. There is no such implication for all contracts at all implied at law. There are some texts like Wilmot that discuss this notion of the implied obligation to perform in good faith at length.
Power nap.
And it's a fairly convoluted area of the law. There's been quite a bit of development of recent times in the UK. It's the obligation to perform in good faith is not by any stretch a certainty in any contract. And in fact, it's not a certainty in any class of contract. There has been some suggestion it should be implied in all commercial contracts. That hasn't really taken hold. Wilmot tends to suggest that it should be implied for all relational commercial contracts. Again, we haven't got that far. Like I said, the UK is probably getting there, but the whole notion of having to perform your obligations in good faith certainly is no certainty at this stage of the game. So we're not going to worry too much about that in this unit. However, if you're interested in relational contracting, like I said, I find it an interesting area. Go and have a look at Wilmot. The other general time when you'll find terms implied in contracts at law is where courts have had a good hard look at certain kinds of contract, and they have said that these terms should be included in all contracts of that class. Okay, so things like contracts for the provision of goods or services, they've got to be reasonably fit for the purpose that they are supplied. Contracts for the provision of professional services, well, the professional has to take reasonable care. Contracts of employment, there has been a stack of terms implied at law for all contracts of employment. Things like, sensible stuff. The employer's got to provide a safe place of work. they've got to tell employees if their rights are going to run out if they don't exercise them at a particular point in time. The employee themselves has to exercise due care. You've got other contracts there. I'm not quite sure why it's bullet pointed as it is, but contracts of shipping, there's an implied term of seaworthiness. There's more. I will leave you to explore those in the text. The main thing to take away from these really is that where a term is implied at law for a particular class of contract, generally speaking, if you wish to exclude the possibility of a court later implying one of these terms, you may do so. So you can include one of those nasty little exclusion clauses that purports to exclude terms that are implied at law, like these ones. However, where you come across, and this is our next kind of terms implied at law, where you find terms implied by statute, often these will not be able to be excluded by the parties. Sale of goods legislation includes a number of different implied consumer guarantees. Again, very sensible stuff, like the seller has title to the goods being sold. The buyer will have quiet possession. That means you're not going to go ahead and interfere with them after the bargain's been completed of the goods being bought. The goods are free from charges or encumbrances. If it's a sale by description, the goods are going to correspond with the description. If the buyer tells the seller what they need it for, then there's an implied warranty that the goods are going to be reasonably fit for that purpose. Where there has been a purchase by description, then it's going to be an implied term that the goods are of merchantable quality, because you haven't had the opportunity to see them and feel them for yourself. You've just gone by a description. If there's a sale by sample, then there's an implied term that the bulk of the goods that you get will comply with the sample. Now, the sale of goods legislation is interesting in some jurisdictions, in some states of Australia, because there's a Sale of Goods Act or equivalent legislation in all of the states and territories of Australia. In some jurisdictions, in some cases, these kinds of terms implied at law can be excluded by the parties if they wish to do so. However, this is in stark contrast to the Australian consumer law, which also includes a swag of consumer guarantees, and these are generally to be found in the Australian consumer law, which is Schedule 2 of the Competition and Consumer Act of 2010. So, like I said, similar guarantees to the sale of goods legislation. You've got to note these can't be excluded. Note section 64, I've got down the bottom there in italics. A term is void to the extent it purports to exclude, restrict, or modify any of the rights or liabilities imposed by the consumer guarantees. The only real exception to that is if the contract does not really fit squarely into the notion of a consumer contract, so it's not really for personal, domestic, or household use. If that's the case, you can exclude the terms. Other than that, any purported exclusion is going to be void. The only thing that you really need to note about the Australian consumer law and its consumer guarantees really is that unlike the sale of goods legislation, because the ACL is federal legislation, so Commonwealth legislation, it is restricted by the Constitution in what the Commonwealth can actually legislate on. And the constitutional power that the government relied on in enacting this legislation was the power to legislate for incorporated entities. And so this legislation is, generally speaking, limited to conduct by companies, corporations, incorporated entities. There are circumstances where the conduct of a person will qualify to fall under the Commonwealth legislation, but if you do wish to nab naughty conduct by someone other than a company, do note that this legislation has been specifically enacted as state legislation, mirroring state legislation in each and every state and territory of Australia. And so you should still be able to rely on that legislation in order to nab naughty people instead of naughty companies. The other thing to note is that this legislation applies not just to sales because of the way that it's worded. So it's a bit broader. Sale, it'll apply to sale, exchange, lease, hire purchase, and also to the supply of services. So there's a few different things to note about the Australian Consumer Law, or the ACL. But they are the final kind of terms that may be implied at law. So that is the notion of implied terms, and we'll come back for the final part of our video series, which will deal with exclusions. It's a quick one. So until I meet up with you again for that last video, bye for now, folks.